One of the biggest reasons for the change is by adopting a uniform law, we'll be able to access as persuasive authority some of the cases that develop in other states' law. My name is Adam Tutaj. I'm a shareholder at Meisner, Tierney, Fisher & Nichols in Milwaukee, Wisconsin, where I practice in the areas of corporate and tax law. And I'm the co-chair of the Chapter 183 Subcommittee of the State Bar Business Law Section. The subcommittee was formed by the Business Law Section precisely to explore possible amendments and changes and improvements to our Limited Liability Company Act, which is Chapter 183 of the Wisconsin statutes. Our committee's been at this project now for almost 4 years, and we've now come up with a series of proposals and recommendations in specific text in terms of actually proposing to adopt a version of the revised Uniform Limited Liability Company Act, or RLCA, which was put together by the National Commission on Uniform Laws. And this would be a pretty big change in a lot of respects from our current Chapter 183. And since LLCs are one of the most widely used entities both here in Wisconsin and nationally, it's a big deal for the business practitioner, and we wanted to take this opportunity here at the Institute to start to introduce ourselves and to start to give people a little bit of heads up of what's where we are in the process and what's coming down the pike legislatively. LLCs have been around now in the Wisconsin since about 1993. We have what's very much a first generation statute. We're one of the first states to adopt LLCs once it became kind of widely approved by the Internal Revenue Service. And we've had the statute more or less in the same form now since '93. And there's been a lot of changes in terms of just the developing business practice, and there's been some case law that's come down that has not been optimal from the standpoint of the practicing business lawyer, and there's still a lot of uncertainty and clarity in our existing law, and that's what motivated the forming of the committee here to kind of look at some of these so-called second generation LLC statutes that are out there. Well, one of the most interesting changes about the new revised Uniform Limited Liability Company Act relates to the specific recognition of oral or implied operating agreements. Currently, you can only have operating agreements that are in writing. The revised Uniform Limited Liability Company Act recognizes kind of the partnership nature of LLCs that, regardless of whether or not the parties set it down in writing, there is still a set of operating agreements and understandings that are out there, and this is a way of giving effect to some of these. One thing that as a committee we are somewhat departing from RLCA is that we are still retaining some limited concept of the written operating agreement, though, because we want to make sure there are some elements that you can change by operating agreement, but they're so important that it makes sense for these to be set forth in writing and not try to rely upon a course of dealing or an alleged oral agreement between the parties. One of the biggest reasons for the change is by adopting a uniform law, we'll be able to access as persuasive authority some of the cases that develop in other states' law. Right now, some version of RLCA has been adopted in 9 states, including California and Florida, which are 2 very large business states. And so now, in addition to our own case law, which we can obviously rely upon, we now have other states that would now have a uniform law whose cases we could look to for at least persuasive authority for our judges as instruction. We don't have that right now because, again, our LLC Act is unique, like a lot of states' acts. These were cobbled together very early on when LLCs first came around, and by now having a more uniform series of laws, we can start to develop a greater body of law to work with and guidance to work with. And so I think it'll be very helpful for the practitioner not only to have some clarity in the statutory language themselves, but also to be able to look to other states and say, this case is very similar, and I can maybe look to this and rely upon some of this analysis. One thing I should say is right now, and this still remains in a draft form. We've just now put together our report. It is now with the Department of Financial Institutions for review. We're hoping to have their comments by the end of this summer, at which point will probably be some further refinement of the language, and we would submit to the Legislative Reference Bureau to start to hammer into shape. And again, one of the things about the committee is that we represented a wide variety of practices. There are large firms represented, there are small firms represented, there's an academic perspective, and what's more, it's not just Milwaukee, but there's Madison. We reached out to over the 4 years a number of colleagues in firms of all sizes because we really wanted to make sure we had the widest range of experiences and input to understand what are areas that people think we need clarification in the law. So we've had a very inclusive process there, and so as this moves forward to the legislative phase of things, our hope is that this will be regarded as a fairly non-controversial and beneficial statute, not just for the practicing bar, but frankly for the business community.